This year we celebrate the 52nd anniversary of Gideon versus Wainwright. And as you all know from your studies, you know that case began here in the state of Florida. And Florida actually responded quickly when Gideon versus Wainwright was decided. And they started to create here a much more formal public defender system in the state of Florida. The legislature, that's one of the things that I can tell you they did, and they did right. They created a system here statewide. There's 20 elected public defenders and 20 elected state attorneys across the state. Our budgets are entirely funded either through the state totally or with a combination with the county. I'm one of those counties that's extremely fortunate that I have a budget in the county government part of life also, and that really helps me a lot, because in this school I can tell that technology is at the utmost, and that is what my county has been able to do for me. So I live and enjoy, and as the dean just said, Hillsborough County is a great place. I know Adam is here who teaches, and he's from the 12th Circuit. And I don't know that the 12th Circuit had the same type of support from the county, but it really makes a difference when your county and your state are both funding your budget and you're able to do a good job. Our office has represented over the last 20 some odd years that I've been the public defender, we've gone anywhere from 55,000 cases per year to 75,000 cases per year. You can see how vast and how diverse the caseloads can be. I'm at the all-time high. I have 120 lawyers in the office. That's an all-time high. And I also am at an all-time high for pending death penalty cases, which is what Adam specialized in over there in the 12th Circuit and continues to be a leader in the education of lawyers across the state in that particular area. For me, the Gideon versus Wainwright case was important because it actually followed what I thought from a philosophical standpoint was so important, and that is that people who walk in different economic lives than some of us do should not in any way be in a position less than that which someone with money might be. My very first job that I had was to be a clerk in the courtroom. And I can tell you that there was no doubt in that short 3.5 years that I was a clerk that I realized that if you did not have a lawyer, whether it be a traffic case, a dissolution of marriage case, a county civil case, if you did not have a lawyer, there was a difference. And so I can tell you that the commitment that I had when I went to law school, and that's why I went, I really wanted to do the work that Gideon stands for. I wanted to work with people who were less fortunate. My private practice, I was very fortunate because I was single at the time. I had a 50-50 practice, which is what I say 50% had to pay the bills and the other 50%, I was more than happy to do pro bono work. And I was more than happy to be a part of the public defender life through special court appointed cases. It gave me great satisfaction, and it continues to give me great satisfaction today, that a lawyer can in fact make a difference. You just heard someone encourage you to do moot court. I did it all when I was in law school, and I did it because, number one, I didn't talk back then at all. I sat in the front row because I was for sure a teacher would look beyond me and I never would have to answer any questions. I just really, and now, clearly I make a living by speaking, and I learned to get past all of my hesitations and all my fears while I was in law school, and it was a wonderful opportunity. I had a great time. And so that kind of tells you how I got here, how we got here in terms of the Florida public defender system and the right to an attorney, a court-appointed attorney, not a free one, but a court-appointed attorney. That was developed, and it was developed through Clarence Gideon and through his case that happened up in the Panhandle. And what we decided was that we would create a system here in the state of Florida that would be rooted in the concept that we had a right to counsel. And that was something that we followed from early on, because as many of you know, we had the Massachusetts Body of Liberties from 1641, and we had some rights that existed back then: the right to a trial by jury, the right to know the charges of your criminal behavior, the right to reasonable bail, the right to protection against cruel and unusual punishment, and the right to assistance by counsel. But it took over 150 years for these concepts to actually be incorporated into the Bill of Rights. So think about how long that actually took. The first case that really tested whether or not we really believed in this right and in this concept that we had developed occurred 130 years after the Body of Liberties. We had the greatest trial of the century. What we have learned to know now in all of our studies from our childhood as the Boston Massacre, you knew that what had occurred was, if you recall, the redcoats, if you recall all the tabloid discussions that were occurring, if you recall how they talked about it in the terms of how horrible and horrific the circumstances were. They were referring consistently to butchery. There had been all kinds of crowds that have been pelted. And one of the things that needed to happen was, if you were going to arrest people, if you were going to charge people, who was going to represent these people if you truly, truly believed in the right of counsel. And there was only one lawyer that came forward at that time to represent the redcoats. There was so much public outcry about what had occurred and about what he was about to do that he lost almost half of his law practice. You know, that's pretty significant. You'll learn that as you develop your own practices, because in today's world, you continue to have scorn and outcry quite often, depending on the underlying facts of cases that can exist. Adam happens to come from a jurisdiction where they were put in the stoplight because of the kidnapping of a young child. And the media pointed out that that person should probably not have been on the streets at the time, and how horrific the facts of that case were. And the scorn becomes driven obviously by the media. We had a case that we are still awaiting the judge's outcome in a death penalty case, where our client on Mother's Day killed his wife and her 2 young children, decapitated and mutilated the bodies, killed the family dog, and stayed within the home for a substantial amount of time before the mother and the grandmother, the mother of the girlfriend and the daughter of the children, came the next day because her grandchildren weren't in the nursery school where they were supposed to be, and walked in to what the Hillsborough County Sheriff's Office called the worst crime scene that they had ever seen in the history of Hillsborough County. In assuming the responsibility for the representation of our client, we knew that there would be public outcry. We knew how the family would react. We knew how their family would respond. There were numerous lawyers in my office that said, I cannot represent this person. It's only happened to me twice in the 22 years that I've been the public defender. It happened one other time when a young 6-month-old child was kidnapped, taken into the woods, and raped. Not touched, raped. The lawyers were lined up outside my door on that case. So it's only happened twice in my career, but in both of those cases, I had to remind everyone, we are the first line of defense for individuals who are charged with these types of crimes, no matter how horrific the circumstances are. And as John Adams said, no man in a free country should be denied the right to counsel and a free trial. It was said then, and it applies today. And although when you take your oath, and although when you read the rules that the Florida Bar has promulgated for us, and although they talk to you about being conflict-free when you're representing someone, as you take on whatever type of practice you take on, the first and the ultimate thing is that you have to believe that you need to be the advocate. You need to be the advocate for your clients. You need to not be judge and jury. You need to be that for which you are here today. All of these rights that we've talked about, all of these rights that existed for all these years, did not, however, for so many years, become actually written as principles that this country would follow and live and die by at this point in time in the Bill of Rights of the United States Constitution. And for those of you that have studied in this area, you understand how important the Due Process Clause of the 14th Amendment is. You know how important it is to have these fundamental rights that exist applicable to our states. You know how important it is to have the assistance of counsel, both in the Fifth and the Sixth Amendments. The right against self-incrimination, the area of the law that is constantly in flux, in my opinion, and that is the Fourth Amendment. The right to a speedy and a public trial, the right to confront witnesses, the right to bail. And I tell you, I know that many of you think that the right to bail is alive and well. So many counties have what's called master bond schedules. So many counties have these preset bails that are set up for whatever charge. And you see an extreme reluctance by the judiciary to deviate from these schedules. And you see that the fact that someone is indigent, what may be de minimis for some of us. Somebody told me I had to pay a $500 bond to get out of jail. I know I got to be able to get those 120 lawyers in my office to kick in a couple bucks a piece to get it. I know that, I'm sure they would do that for me. But for some people, there is absolutely no way and no one that can do that. And so that is an area that we are constantly encouraging our lawyers to litigate in. And obviously the right to cruel and unusual punishment. How important is the right to cruel and unusual punishment? Adam and I were just talking about what a wonderful day yesterday was. The Florida Supreme Court, in 4 tremendous opinions, have decided that Florida must subscribe to what the United States Supreme Court has said about juveniles and juveniles being sentenced to life imprisonment. They have said, not only are we going to follow it, ladies and gentlemen, it is going to be retroactive. That is so significant. So significant because although we, as defense lawyers, read opinions and we see the glass really half full, the interpretation of those same cases by the prosecutors, by judges, quite often do not follow the thought process that we think was behind the analysis of the Supreme Court. And the courts in Florida, across Florida, have been imposing sentences such as 50 years followed by 50 years or 90 years in juvenile cases where there was eligibility to be resentenced. And in those cases where we were asking for retroactivity application, we were being shut down all across the state. So yesterday was a significant day for the right to counsel because it is through the lawyers who continue to battle in the courtroom day in and day out against all odds, against being shut down constantly, against no hope, against really, when you think about it, again, public outcry. Because what do you hear about and read about? The worst of the worst. You only hear about this one case that, oh, look how horrific this was. And please understand something. There is not a lawyer that practices in the area of criminal defense law that does not know the pain and suffering that people go through at the hands of others. Please don't ever think that. But again, our job is to ensure that our protections and that our system works and works correctly. And you have to set aside those personal feelings, and don't ever think that we don't have them. Don't think that we don't go home and lose sleep. Don't think that we don't go home and answer the question from your child that says, was that you on TV representing that person that did all those horrible things? We all go through that. But it is the greater good that we must all focus on. We must remember that in all criminal prosecutions under the Sixth Amendment, the accused shall enjoy the type of defense that is a true zealous advocacy. We're not dotting I's and crossing T's. This is a right that is so important that you have to fight for it every single day. And although it's applicable and clearly applicable in felony cases and in all these serious cases, I want you to know that we fight just as hard in misdemeanor cases because of the sentencing schemes that exist in this state, where a person who is convicted of multiple misdemeanors can become involved in the felony court system. And so we are constantly in all areas, whether it be juvenile, county court, felony courts, death penalty cases, we struggle and fight every day to hold sacred this Sixth Amendment right. And I'll tell you, if you've never ever read the books on the Scottsboro Boys in your spare time, I'm going to encourage you to do so. 9 black teenage boys accused of rape in Alabama in 1931. I'm sure you can imagine what that might have been like. The amazing thing is that a posse is put together. There's a search and arrest of these boys. And what you had in the court system was a desire to move these cases as quickly as you could through the system to avoid the violence of the outcry of the public. So the first trial only took a day and a half, and the other trials were all one right after the other. In today's world, jury selection in a rape case takes the day and a half, if not more. The only attorney who volunteered to represent these individuals was a person that was 69 years of age. And that sounds old until you hit 60. And then it's not. Who had not defended a case in decades, who was a real estate lawyer. And the only access that these folks were given, that these kids were given to their lawyers, was immediately before the trial, with absolutely no ability to prepare a defense. Today's world, in death penalty cases and in rape cases, you take easily a year, 2 years, 3 years to prepare these cases. And as the verdicts were being returned, you could hear a band playing music, and the song was, "There'll be a hot time in the old town tonight." That gives you an idea of the sentiment that was going on. Those arrests had occurred on March 25th, 1931, and the trials began April 6th. That's the kind of justice that's done in other countries. That is not the type of justice that the United States of America can stand for. The trials were all done by April. 7 of the 8 convictions were upheld by the Alabama Supreme Court because they felt that the lawyer that represented them had thoroughly cross-examined the state's witnesses and presented the evidence that was available at the time with no preparation. So you know what kind of things were done during that trial. Really nothing. How could there be? You hadn't even had a chance to talk with your clients. The Alabama Supreme Court reversed the conviction and death sentence of one of the 13-year-olds, and he was granted a new trial. The holding in Powell versus Alabama was, if the death penalty is a possible sentence, you're going to be entitled to the appointment of an attorney at state expense. And for those of you that have studied in the area of criminal defense work, you also know that the assistance of counsel means the effective assistance of counsel, but we needed another case to tell us that. And that was obviously, as you know, the Strickland case. It's extremely important for all of us to realize the development of these rights, and look how slow, and look at the injustices that were done. And that's why when you hear that public defenders and assistant public defenders are zealous advocates, it's because this is the history that we know. When you're doing appellate work, you know, I have judges that tell me all the time, I don't need all the history. I just want to know about the case today that exists. Appellate people will tell you it's great to remind everybody of history because of where we've been and where we don't want to go back. We need to make sure that our rights are not in any way diluted because people forget why we have the rights and why we don't want to return. 6 years later, the Supreme Court ruled in Johnson versus Zerbst that the Sixth Amendment required the appointment of counsel for all indigent defendants charged in federal courts. That's important because the federal courts have also created a very substantial and robust public defender system. For the majority of the cases in the state's court, you need to remember that the Powell decision stayed intact, but we were a little bit upset in the Betts case because they ruled that it was only going to be applicable for special circumstances. So you have this great victory, and then you have someone trying to dilute it. So it's important to know why we do what we do. The Gideon case is the one that we all obviously love and admire, because every time you think about someone who is poor, had an 8th grade education, was a drifter, by the age of 16 had already joined into the world of not only living in poverty, but being involved in petty crimes. And while he was living in Panama City, a pool hall was broken into and a big $5 and change, a few bottles of beer and soda were stolen from the pool room. And Mr. Gideon was identified by some witnesses who said that they had been walking around in that particular area. He was arrested at another tavern in June of 1961, and he went to trial in August of 1961. Today's world, you get arraigned if you're lucky at that point in time. The trial began on August the 4th, and I want you to just 2 minutes see a quick little video and think about how what you're hearing is the cornerstone of the world that I live in now, and what we fight for on a daily basis now to keep alive. Now, we all know that this video was not created at the time that he was first denied the attorney. But think about how important everyone thought that this decision was, that everyone decided to come back together and put this video together for historical purposes. That's how significant everyone thought this decision was. And what's interesting is that you heard from the lawyer that was representing Mr. Gideon. The lawyer who was asked to oppose this request, who was sent to the United States Supreme Court to argue against this right, had the Attorney General of Florida send letters along with the Attorney General of all the other states asking for their support in defending this case. So you had all these attorney generals that were opposing this extremely critical right to counsel. But there were certain states that said, you know what? No. We understand the injustice. And so you had a couple of states that actually would not oppose it. More importantly, the man arguing against this right was doing what he had been hired to do, but in his heart knew it was the wrong thing to do. and understood that ultimately it would be extremely important to have this case resolve in the way that it did. But he did his job, and he did it well. If you ever go back and look at the transcripts of the hearings, he did it well. He did it very well. But he talks to you today, in today's world, about how important and how critical he understands the right to an attorney is. It's so important to know that when you're in an adversarial system, the system is only as good as the people that are in the system that are advocating their positions. You have to be ready, you have to be prepared, you have to understand why you're arguing for what you're arguing for. But what you should never lose sight of is fairness, justice, impartiality, and that the system is greater than us. That personal feelings don't belong in these cases, and your zealous advocacy doesn't rise or fall on the facts of the case, but on the application of law to those facts, the application of law to the concepts of liberty that we have all adopted and that we cherish in this country. There is no doubt that Mr. Gideon, who you saw, was not capable of representing himself. He was not capable of understanding the rules of evidence, courtroom procedures. Upon retrial, he was found not guilty. That's pretty significant. That's pretty significant. If you think I'm passionate in this area, I am. The dean mentioned where I went to school. Not USF, because but mentioned that I went to school in Texas. Texas assisted us in having to have the United States Supreme Court also say that it was probably a good idea that lawyers not sleep during trials. Think about that. And you had judges that were entering opinions saying the evidence was so overwhelming that there really isn't anything that a lawyer could have done to undo that overwhelming evidence. Anything appears overwhelming if not challenged. I am challenged on a daily basis to suggest to attorneys, just because the police report says it doesn't make it so. You're right. That isn't the whole story. That isn't everything. There's a reason why I love the state of Florida. And Dean, I know you're coming on our side on this, right? How could you not love living in a state of Florida where you have the discovery opportunities that you have? You can start on day one being the zealous advocate. You can start on day one making sure that all of our liberties and all of our protections and all of our rights are protected. You can start on day one preparing your case, not only for trial, because one of the things you'll learn quickly is post-trial. Because if you have a conviction, what you did that day does matter. What you did in preparation does matter. You should every day, and I'll tell you, I know there's people out there that are going to become prosecutors. Do your job well also. I just happen to come from the other side where I believe that the right to counsel, to effective counsel, to counsel that lives and breathes the cases, to counsel who does not judge others, to counsel who understands the rules of evidence, the rules of criminal procedure, who understands the Constitution, who understands that but for you, just like but for Clarence Gideon, he would have been in prison serving a sentence instead of not guilty. But for all these wonderful lawyers that exist in the state of Florida and across the country that have fought life sentences for juveniles. We're not talking about juveniles at 17. We're talking about juveniles 13, 14, 15, 16 years old. But for the United States Supreme Court and its checks and balances on all the states across the country, but for them being cognizant of pleadings that they receive, even if they are on a napkin, but for their clerks who read things constantly, we wouldn't have this constant overview and checks on a society that sometimes decides that public outcry is more important than constitutional rights. One individual person's pain is horrible to live with. You're not looking at someone who has been untouched with things in their lives. When I was 16 years old, a very good friend of my family's was kidnapped and murdered. I am not someone who has lived in a perfect world where nothing has ever touched me. But you have to let the system be in place. You have to have the Constitution in place. You cannot have the system not be greater than me or someone else who's going through pain. Is it hard? Yes. But ladies and gentlemen, it is the purest form of being a citizen in this country and believing in the things that we fight for day in and day out. I urge you to find your calling. I urge you to find your area of practice that you can give it your all. And I urge you to remember why. Every single day, why did you come to law school and why did you work as hard as you did? But I promise you one thing, this is nothing compared to what you will be doing when you have other people's lives in your hands, their children. It's a wonderful calling. Don't ever, ever, ever allow anyone to say that this is not an honorable profession. It is the best. I love it. As I walked into the halls here, I thought about, I love law school. I was one of the few people, I love law school. At USF, I was wondering, what am I taking these classes for? I loved law school. So you can. 33 years later, still love like you did the first day. Thank you all very much and enjoy.